we have not been able to address the problem of a national vacancy rate. At the moment, the figure stands at 26% of our trial courts have no judges. That means that at least 1 of every 4 trial courts has no sitting judge. It is no wonder then that our cases get delayed and delayed and delayed. Until these vacancies are addressed, I don't think it will be possible for us ever to catch up with our clogged dockets. But that is not all. If you add the cumbersome court procedures which were designed for a different or jury system, that makes it even worse. Because you have judges who are not there, we lack appointees. At the same time, the judges who are sitting are applying rules that were not designed for the Philippines. They were designed for a jury system, which we do not have. It may interest you to note that our rules on evidence were copied almost word for word from the Code of California. So we can say that our rules are imported of California vintage. It may also interest you to note that our rules on civil and criminal procedure were patterned very much after the federal rules of civil and criminal procedure of the United States. Now, I have no issue with doing that. That's not plagiarism. We can copy those forms. But my issue there is that we don't have a jury system. And those rules, those procedures that we copied are all designed for a jury system. What is the difference? The United States follows what is called a bifurcated system. The judge is the one who decides what the law is, the jury decides the evidence, and the jury decides the case. They decide who will win, they give the verdict. But that, in our country, is not the same. In our country, the judge and the jury are all combined into one person. Question: so why then do we have to follow all those cumbersome rules designed to screen out inadmissible evidence so that the jury will not hear it when we don't have a jury in the first place? We have been following rules designed for a different system for over 100 years. Isn't it about time that we develop rules that are consistent with our own concept of justice? And this is a challenge I hurl to all of you young people out there, for you to do that. If you could do that, the country would love you forever. There is now a new rule, the judicial affidavit rule, that will be put in place in January of next year, which hopefully will shorten proceedings, and I think the court is going in the right direction with this rule. However, I would give some caution to the court insofar as criminal cases are concerned, because too much use of the judicial affidavit rule may interfere with the burden of proof of the prosecution in criminal cases. It may affect the right to a fair trial of an accused and even his right to cross-examination. The problem I have with the judicial affidavit rule is that the credibility of a weak witness and a strong witness is the same, because the judge will not be able to examine and observe that witness on direct examination. So let's say I have an expert. I have a weak expert and a strong expert. If I use a judicial affidavit, my weak expert can become strong because the judge cannot see him speak. The judge cannot determine or assess his credibility. Perhaps in civil cases, that's not so important, but in criminal cases, especially those where major penalties will be imposed, I think it's very important. So there should be safeguards that should be imposed on criminal cases.